This case opens with a claim that immediately raises red flags. A father tells the court he has no money, while the other side alleges tens of thousands sitting quietly in the background. What starts as a routine child support hearing quickly turns into a credibility test. Who's telling the truth, who has documentation, and how much weight does the court give to verbal claims versus financial records? As you watch, pay close attention to how income is established, how prior incarceration affects support orders, and how fast a simple question can spiral into a courtroom moment that changes the entire tone of the hearing.
He told the judge he had no money, which he had $70,000 that he
All
put in
right,
a checking account.
Ms. Calkins, how much do you make an hour?
$10 an hour.
He makes $20 an hour, and
How do you know this?
because I have bank statements at my house that I have right here in front of me.
From wait,
But he makes deposits every Friday at his banking account.
I make a
hold on,
$50 deposit every
hold
Friday.
on, Mr. Calkins. Hold on, wait, because now I'm intrigued. All right, hold on a second.
At this time, the state will call Jody Calkins. Ms. Calkins, why wasn't there any child support ordered in the divorce decree that was from April 22nd, 2021?
This is a very good show. This is where things get interesting. The state explains why no child support was ordered initially, incarceration and a claim of zero funds. That matters legally. Courts cannot set support based on money someone does not have at that time. But now, the issue isn't the past. It's whether income exists now. Bank statements enter the conversation and the judge's attention sharpens. Documentation changes everything in family court. Claims are easy. Paper trails are not. Ask yourself, if you were the judge, how much weight would you give statements found outside official disclosure?
Because Matthew Calkins was in Sabine County Jail, and he told the judge he had no money, which he had $70,000 that he put in a checking account.
Ms. Calkins, so the reason why there was no support set in the previous order was because he was incarcerated at the time?
Yes, and said he had no money.
Right. And are you asking the court today to set child support and medical support?
Yes, sir, I am.
All right. What kind of health insurance do you have for your child, JC Calkins?
He has Medicaid.
All right. I have no further questions. I pass the witness.
Call you next week.
At this time, the state will call Mr. Calkins. Mr. Calkins, do you have any other minor biological children who are below the age of 18?
No, sir.
Where are you currently working?
Here in Hemphill, Texas.
All right.
This is a very good show. Here, the father testifies directly about his employment, construction work, hourly pay, and roughly 40 hours a week. On paper, this sounds straightforward. Courts rely heavily on sworn testimony when no immediate contrary evidence is formally introduced. But notice the tension. Earlier, we heard allegations of higher income. This is a classic family court problem. Two versions of financial reality, both incomplete, both emotionally charged. Viewers should note that judges must rule using the best available verified information, not suspicion alone.
What do you do for work?
Construction.
Okay. Are you paid hourly?
Yes.
How much do you make an hour?
$10 an hour.
And how many hours do you work on average each week? And how many hours do you work on average each week?
About 40 hours a week, give or take, depending on weather and stuff.
And does your employer provide any health insurance?
No.
And do you have any other sources of income, or is that your only job?
That's my only income.
I have no further questions for Mr. Calkins.
Calkins, yes, sir.
All right.
I would like to call Ms. Calkins back for one additional question, Your Honor.
Okay.
Ms. Calkins, do you have any safety concerns about your address or contact information being disclosed in any order of the court?
No, sir.
All right. No further questions.
Can I ask some questions about visitation?
Nope.
That's not.
They didn't file a lawsuit, Ms. Calkins, about visitation. Just child support.
Okay.
So, no, you can't ask questions about visitation, but I don't mind telling you that I can't address visitation because nobody filed a lawsuit about visitation.
Okay.
The only issue before me today is the child support and the medical support. That's it.
Okay. That's fine.
Ms. Calkins, was there anything else that you did think I needed to know about the case before I made a ruling in regards to the child support and the medical support?
He makes $20 an hour, and
How do you know this?
because I have bank statements at my house that I have right here in front of me.
From, wait.
But,
these
he makes deposits every Friday at his banking account.
I make a
Oh, wait,
$50
wait.
deposit every
Hold
Friday.
on, Mr. Calkins.
This is a very good show. This moment is pivotal. The judge stops everything because access to someone else's bank statements is not a minor detail. How documents were obtained matters almost as much as what they show. Were they opened? Were they current? Were they legally accessed? Family court judges are extremely sensitive to privacy violations, especially when credibility is already under scrutiny. This exchange shifts the focus from income to reliability. Once credibility wobbles, the entire argument can weaken. This is a lesson many litigants learn the hard way.
Hold on, wait, because now I'm intrigued. All right, hold on a second. Ms. Calkins, do you work for the bank?
No, sir.
How do you have Mr. Wait, just to answer my question, okay? Don't keep rambling on. How do you have access to Mr. Calkins' bank statements?
Because all his stuff is here.
I don't know where here is.
He's at my residence.
Okay, so all of his bank statements come to your house?
As far as I know, they have been, but
Okay,
these are
hold on,
these
hold
old
on.
statements
Wait, these are old statements from when?
from August of
What year?
20 this year, August 31st of 23.
All right, so you have Mr. Calkins's bank statements. Quit moving around, Ms. Calkins. You're making me,
yes,
you're
sir.
making me sick.
I'm
Okay.
sorry, I had to get up.
It's
and
okay.
look at the paper.
So Mr. Calkins's bank statements come to your house. They're mailed to your house.
Yes, sir.
All right. And you open them.
No, this was on. These are some old ones that was on top of the refrigerator.
All right. Well, they're not that old, ma'am, if they're from August
Well,
of
I mean, no, it's just,
23.
I found it on top of the refrigerator.
Mr. Calkins, how did your bank statements get on top of Miss Calkins' refrigerator?
And I don't know how they got opened. You're completely right, sir. I've been living here before August 31st.
Did you happen to leave some mail behind with Miss Calkins?
I didn't take no mail with me.
Okay. So it's possible you left bank statements behind.
Possibly, yes, sir.
Okay. Because you haven't opened any of his bank statements, right, Miss Calkins?
No, sir. It was
That'd be-
already been. It was his bank statements laying up there on the
Ah.
refrigerator.
All right. Mr. Calkins, is there anything else you think I need to know about this case before I make a ruling?
No, sir.
When did you get out of jail, Mr. Calkins?
July 27th to 22.
So you've been out of jail for what?
A little over a
16
year.
months?
This is a very good show. Now the court uncovers something crucial. The parties lived together after incarceration and only separated about a month before this hearing. That context matters. When parents cohabitate, financial support often happens informally. Rent, groceries, utilities, without court orders. Judges factor this in when deciding whether support was intentionally avoided or simply not necessary at the time. This timeline simplifies the court's job. It reframes the issue as forward-looking support, not punishment for the past.
About that, yes, sir.
Since he's been out of jail, Miss Calkins, have you and Mr. Calkins been living together?
We did at one point, yes, sir.
When did y'all separate?
We
A couple months
separated.
ago.
Hold on, I'll get to you, Mr.
Oh, I'm
Calkins.
sorry.
That's all right. I wasn't specific. That's not your fault. When did y'all separate, Miss Calkins?
In August.
Okay, so you've only been separated a month.
Yes, sir.
Okay. That makes things a little easier. Miss Calkins, are you and Mr. Calkins legally married?
No, sir.
All right, because y'all have the same last name.
Yes, sir.
Why do you have the same last name, Miss Calkins?
I can't. When I got to the divorce, it came across pretty quick, and I just
Never mind. I'm sorry. You're good. You got divorced in 2021. You had his name then. Don't worry about it.
Yes, sir. That's fine.
Sometimes I get focused on the issue and I forget where it is I am. Okay.
Yes, sir. That's fine.
All right. Anything further from the state?
Nothing further, Your Honor.
Mr. Calkins, is there anything else you think I need to know about this case before I make a ruling?
No, sir.
This is a very good show. This is the legal bottom line. Based on the testimony and available evidence, the judge sets child support at $300 a month and medical support at $50. This is not a moral judgment. It's a statutory calculation grounded in income claims and state guidelines. Notice what the judge does not do. No retroactive penalties, no assumptions of hidden wealth, no escalation beyond what the evidence supports. Family court is often criticized, but moments like this show restraint and procedural discipline.
All right. Child support's $300 a month, medical support's $50 a month, beginning October the 1st of 2023. And every month thereafter until the emancipation date of the child.
Yes, sir.
Court costs are due by Mr. Calkins, but I will give him until March 31st of 2024. How's that?
And what is the amount of the court cost?
No idea, Mr. Calkins. No clue. I'm in 9 different counties, Mr. Calkins. I have no idea what the district clerk's office.
When and how would I be able to find out?
So when I'll sign the order that they send to me and I'll send it back to them, then they'll make a copy of it and send it to you. The AG's office will send it to you. Contained within that order will have the information for the Sabine District Clerk's office. You can call.
Now, will I be served, or do they have my address?
Well,
I haven't set up. I haven't set up the case yet
You haven't set up a
with
case.
the AG's office.
Well, I mean, the address that's going to be in my court order, wherever they served you.
Oh, that was at Sabine County Jailhouse then.
Oh, okay. Do you have a good address on him now, Mr. McNulty?
North Texas Street in Hemp Hill.
Is that right, Mr. Coughlin?
Yes, but there's another address that it could be. There's two possibilities, 2 different addresses on Texas Street.
Well, I don't want you
One was my.
I don't want you broadcasting.
One was my parole address, and one's my address now. That's what I'm trying to see. I mean, I'm not. I don't care if anybody else knows my address. I don't.
Okay. I mean, it's just going to be broadcast to the internet. So if you just blurt it out, everybody that watches is going to be able to see it.
But that's fine. It's Texas Street.
Is that what you got, Mr. McNulty?
Mm-hmm. Yes, sir. Yes, Judge.
Okay. They have your correct address, Mr. Calkins. So when they send you the order, in the order will have the information about how to contact Sabine District Clerk. You can contact the district clerk and they'll tell you how much you owe them.
Okay.
And then you'll have at least, 6 months from then to pay them. Okay.
This is a very good show. This case highlights how family court actually works behind the scenes, not on emotion, not on outrage, but on testimony, documentation, and legal thresholds. Income must be proven. Privacy matters, timing matters, and judges can only rule on what's properly before them. Whether you agree with the outcome or not, this hearing shows why preparation and credibility are everything in child support cases. If you found this breakdown helpful, take a moment to like the video, share your perspective in the comments, and subscribe to The Legal Watch for more clear, fact-driven courtroom analysis.